SJC-13381, Robinhood Financial, LLC, v. Secretary of the Commonwealth.
Attorney Fisher-Groban.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. Assistant Attorney General Phoebe Fisher-Groban on behalf of the Secretary of the Commonwealth and the Massachusetts Securities Division. The Massachusetts Legislature granted the Secretary the authority to protect vulnerable investors in the Commonwealth by defining what unethical conduct means under the Massachusetts Uniform Securities Act. The Secretary's fiduciary duty rule protects consumers by requiring that when they receive investment advice or recommendations from a financial professional, that advice is provided to them without a conflict of interest. And this rule is—
So that fiduciary rule was proposed by the Secretary to the SEC, and the SEC rejected it. Why is it there not a conflict preemption?
Your Honor, there is not preemption here because for preemption purposes, we look to what Congress's purposes and objectives are. And here in Dodd-Frank, which is the statute that authorized regulation best interest, which was ultimately promulgated by the SEC, Congress's first, its intent was to protect investors. And second, in the statute authorizing the SEC to engage in rulemaking, it specifically authorized the SEC to do exactly what Massachusetts has done here. And so Robinhood's burden, and it bears a heavy burden to establish preemption, is to show that somehow what Massachusetts has done and the fiduciary duty rule stands as an obstacle to the purposes and objectives of Congress. But here, Massachusetts has done what Congress told the SEC that it could do in Dodd-Frank.
Well, when we do the preemption, do we look at what Congress authorizing scope to the SEC was, or do we look at the SEC's rulemaking?
We look at Congress's purposes and objectives, and the Supreme Court has repeatedly emphasized and recently reiterated that what's important here and the touchstone is congressional intent and congressional purposes and objectives. So here, the congressional purposes and objectives are, in Dodd-Frank, of course, to protect investors, which the fiduciary duty rule does, and Congress also authorized the SEC to do precisely what Massachusetts has done, which is to promulgate a rule that requires that when providing investment advice to retail investors, that broker-dealers hold themselves to the same standard of care only with respect to that function as investment advisors. So what Massachusetts has done is completely consistent with congressional purposes and objectives.
Doesn't the statute, though, suggest in 913B that, well, we're not going to resolve this preemption issue, we'll see what happens?
Well,
pursuant to the study?
In its regulatory, Your Honor, to make sure I'm understanding your question, are you referring to the SEC's regulatory record?
Right.
Yes. So that the SEC did, of course, say that it said nothing about preemption, and it said if and when there's litigation, we can address it then. But what's important here is that the SEC's record doesn't express anything indicating that it understood Congress's intent was to set a ceiling. And it's also important to note that in the SEC's regulatory record, they acknowledged the fact that many states at common law already hold broker-dealers to a higher standard of care. So the SEC...
Not this state.
Pardon me?
Not this state.
Well, Your Honor, I'm glad you asked that, because I believe you're asking about
Please finish Justice Lowey's question.
Sure. To finish the answer to your question, here the SEC acknowledged that states impose a higher duty of care on broker-dealers. It expressed no discomfort with that fact, but acknowledged it. But what's most important here is congressional purposes and objectives. And the SEC's regulatory record is absolutely silent about the notion that Congress, by authorizing its rulemaking, would have intended, if in the situation which happened here, where the SEC imposed something lower than a fiduciary duty of care, that that would now be the ceiling for all broker-dealer fiduciary duties.
The question I have is, can the Secretary of State by regulation overrule PATSOS?
I have two answers to that question. And the first is that the Secretary of State didn't overrule PATSOS. And here's why, and there's two reasons why. The first is PATSOS is about discretionary accounts. In PATSOS, the court was deciding whether, when a broker-dealer has taken on discretion with respect to an investor's account, that broker-dealer owes a general or ongoing fiduciary duty. Here, the fiduciary duty rule doesn't impose an ongoing fiduciary duty on broker-dealers. Rather, it says, when you engage in the function of providing investment advice or recommendation, and only with respect to that conduct, you owe the customer a fiduciary duty, which means you need to comply with a duty of care, and you need to comply with a duty of loyalty, which means you can't have a conflict of interest. PATSOS, in fact, said really only one thing about the situation that the fiduciary duty rule addresses, which is non-discretionary accounts, again, where the broker-dealer is not effecting transactions without getting the approval of the customer. And it said, for non-discretionary accounts, each transaction is viewed singly. The broker is bound to act in the customer's interest when transacting business for the account, but all duties to the customer cease when the transaction is closed. And the fiduciary duty rule is consistent with that. So the fiduciary duty rule is consistent with PATSOS, but secondarily, it doesn't override or abrogate PATSOS in any way. And that's because a common law breach of fiduciary duty claim still exists for an investor. An investor can still bring a breach of common law fiduciary duty claim against a broker-dealer. That would be analyzed under PATSOS, the Uniform Securities Act. The fiduciary duty rule would not come into play. The fiduciary duty rule can be enforced by the secretary and not an investor. So the fiduciary duty rule hasn't abrogated the common law breach of fiduciary duty claim, which is still available for retail investors who wish to bring one against their broker-dealer.
To go to something you sort of jumped over pretty quickly, which was the definitions, because I think what one of the issues here that Robinhood has is that, not in the constitutional sense, but that they have that too, as separation of powers, but that the delegation here just does not allow for this regulation, that the statute doesn't provide the delegation that the secretary has taken, specifically as it relates to the definitions of dishonest and unethical. Can you address that?
Your Honor, the Secretary's definition of unethical conduct to include when a broker-dealer provides advice with the burden of a conflict of interest is a reasonable interpretation of that term. And the Massachusetts legislature specifically authorized, it set forth a legislative purpose, which is to protect investors, and then it set forth a standard, which is unethical or dishonest conduct, which the Secretary is empowered to enforce and to promulgate detailed definitions explaining what unethical conduct looks like in Massachusetts.
How do we measure that? How do we know what is a reasonable definition of unethical conduct? Because the opposing party says it has to be based on industry standards.
The opposing party's argument that what is unethical is based on industry standards finds absolutely no support in the text of the statutes itself, which is
well, they point to some black log definitions, which seems persuasive.
The definition of the term unethical is granted to the Secretary. And here, the statute itself, the plain language of unethical, it is a reasonable interpretation of unethical to include acting with a conflict of interest. If unethical can't include conflicts of interest, I mean, that gets to the core of unethical conduct. And here, the statute authorizes the Secretary and not the broker-dealer industry to say what unethical conduct is here. And helpfully, here, regulation best interest, we cited this in our brief, regulation best interest, for example, recent SEC bulletins have explained that under regulation best interest and a fiduciary duty standard of care, the results are kind of the same, which is—
Well, that was my next question, is what's the difference?
Sure. I'm glad you asked that. These SEC bulletins make clear that the real difference comes in the conflict of interest piece. The SEC has made clear that under regulation best interest and under fiduciary duty, the duty of care looks similar, which is to say a broker-dealer still needs to make an inquiry about the details of the recommendation they're making, and they need to know things about the investor they're making the recommendation to.
Okay, so what are the differences?
The difference comes in the conflict of interest piece, which is to say the fiduciary duty rule requires a broker-dealer to seek to avoid conflicts of interest. If they can't be reasonably avoided, to eliminate those conflicts of interest, and if they can't be reasonably eliminated, to mitigate those conflicts of interest. Whereas under regulation best interest, it appears that merely disclosing conflicts of interest can be enough. And the Secretary in his regulatory record cited compelling evidence that disclosures aren't enough to protect retail investors. They don't understand what they mean, and they don't understand that when a broker-dealer is providing them with an investment advice, that broker-dealer may be doing so because of a sales contest. In other words, that recommendation may be burdened by a financial interest of the broker-dealers. And so that's the key difference between regulation best interest and the fiduciary duty rule, which is to say regulation best interest may be satisfied potentially by merely disclosing conflict, whereas the fiduciary duty rule says that broker-dealers should attempt to avoid, eliminate, or mitigate those conflicts. And another key difference is that the regulation best interest appears to permit kind of broader-based sales contests. I believe the words they use are limited time sales contests. So the fiduciary duty rule says no sales contests are permissible because, of course, that could introduce the potential for a conflict of interest.
Well, investor protection, you keep on saying investor protection, and if I were there, I would as well, and with good reason as far as being a purpose here, but it's not the only purpose here. There's also concerns when you look at the SEC, at least, about investor choice, and the Uniform Act has concerns about some consistency throughout the country, and that's been raised by Robinhood as well. How do you address whether or not this is these regulations are a permissible delegation, considering that those are also purposes at play?
Your Honor, the drafter's commentary for Section 415, which is the provision that encourages uniformity. Right. 412B, that uniformity provision only applies to certain ministerial things, so it doesn't apply here. But 415, which discusses uniformity, the drafter's commentary makes clear that uniformity is not required. And so the Secretary's promulgation of a rule that is the first of the other states that have uniform acts does not mean that that rule is ultra vires of the statute or beyond the Secretary's authority, because the drafter's commentary specifically speaks to this situation, which is where a securities regulator sets an administrative precedent. And other states can, but are not required to follow that administrative precedent. And so while the statute encourages uniformity, the drafter's commentary makes clear that that's only a secondary aim of the statute and only insofar as practicable.
Investor choice?
Investor choice is not a purpose of the statute. Investor choice is discussed by the SEC in its rulemaking associated with regulation best interest, but that's not a purpose of the Massachusetts Uniform Securities Act. and investors
You
still.
address the question, raised, or I guess the point raised by Robinhood that structurally the MUSA is, treats broker-dealers different than investment advisors. And so this particular rule is ultra vires because it's treating both the same.
This rule does not treat investment advisors and broker-dealers the same. It respects their traditional distinction, and here's why. Broker-dealers traditionally, as Robinhood emphasizes in its brief, merely effectuate securities transactions. Investment advisors...
You're saying when brokers-dealers dip their toe into providing some sort of advice, be it a list or, encouraging repeated transactions, then they are outside of their traditional zone and so should be treated more like investment advisors.
Yes.
And that's a reasonable interpretation by the Secretary.
Yes, and while broker-dealers, they are permitted to give advice that's incidental to their traditional role in affecting securities transactions, the Secretary in his rulemaking recognized that, and the amicus briefs in this case are helpful on this point too, and we cited it, that increasingly broker-dealers are providing investment advice and recommendations and holding themselves out as trusted advisors. So what the fiduciary duty rule does is it doesn't fundamentally change the relationship between a broker-dealer and its customer, the traditional relationship. What it says is, if you're going to provide investment advice or recommendations, your client, the investor, is entitled to have advice that is made in their best interest and that is not conflicted. And so it applies to the function of providing advice, but keeps these two relationships that are recognized in the Act intact.
Any other questions? No. Okay. Thank you, Counsel.
Oh, thank you, Your Honor.
Teresa Haria.
Good morning, and may it please the court. Amy Saharia for Appellee Robinhood Financial. This court should affirm the Superior Court's ruling that the fiduciary duty rule exceeds the Secretary's authority under the Massachusetts Uniform Securities Act. The Act does not give the Secretary the power to make conduct that is ethical under existing federal and state law unethical simply by announcing it to be so. The Secretary's contrary and limitless reading of the Act defies the plain meaning of the word unethical. It conflicts with the Act's history, structure, and purpose.
But why is it unreasonable to say that unethical includes situations where you do not avoid a conflict of interest, you do not eliminate that conflict of interest, or you do not mitigate it? Why is that unreasonable?
Because the entire premise of the broker-dealer model is that broker-dealers have a conflict of interest when they execute a transaction on a transaction-by-transaction basis. Because
Right, but when they dip their toe into starting to give advice, why can't we treat them? Why is it unreasonable for the Secretary to treat them more like an investment advisor and require them on this conflict of interest point to avoid them, eliminate them, or mitigate them?
Sure, let me give two responses. So first, the law has recognized both federal law, the federal securities laws, as well as the Massachusetts Act, that broker-dealers can give recommendations incidental to their broker-dealer duties, and they are still a broker-dealer as long as they are not being compensated as an investment advisor. So that change in the law by the Secretary is a change in the law as it relates to broker-dealers making recommendations. Now, turning to the common law, this court has recognized for a century, going all the way back to Brown versus Corey, which we've cited, that broker-dealers do not owe fiduciary duties to customers unless they are exercising discretion and control, unless there are special circumstances, even when, in the language of Brown v. Corey, the customer is relying on the expertise and knowledge of the broker-dealer.
And so the investor doesn't have a cause of action under the common law, but why can't the Secretary hold clients like Robinhood to a higher standard under the Uniform Act?
Sure, because this court has long held that the legislature is not presumed to have altered or abrogated the common law absent an express statement.
Well, no, there's no abrogation of the common law. The investor still has the claims that he or she would have had under Patsos. It's just that the Secretary now can bring an action for unethical conduct, revoking somebody's license to practice in Massachusetts, and to offer their securities when they act unethically, as the Secretary has defined it. Why is that unreasonable?
That is an abrogation of the common law as it relates to the broker-dealer, because the broker-dealer now has no choice but to comply with the fiduciary duty as the Secretary has enacted it. The common law does the broker-dealer no good in that circumstance. But I think the key point here is that this court needs to...
So you're saying the common law was to protect the broker-dealer, and the broker-dealer's rights under Patsos have been violated by the Secretary's redefinition of unethical?
Well, the common law exists not only for the protection of investors, but also for the protection of broker-dealers. It provided clear rules to broker-dealers. And I think the issue
But
here...
this rule is clear.
This rule is clear, and we think it clearly violates Patsos. I mean, there are aspects of the rule that are not clear. The parties very much dispute whether Robinhood even provides recommendations, but that's not an issue for this court. That would be an issue for the administrative proceedings. But the issue here is that we are defining the words unethical and dishonest for purposes of the Act. And the Secretary has given those words no independent meaning in the Act. As I take his reply brief and as I take his argument here today, he can give those words any meaning he wants.
But again, that's not the case that we have here right now, right? Your argument is about defining unethical and dishonest to include the fiduciary duty rule.
That's correct.
Okay, so it's not, this question about the sky is falling, the Secretary can, say, wearing blue is unethical. I mean, that's just not what the case we have here. We have a specific rule, and the question is that a reasonable interpretation of what's unethical?
Sure, and we think this rule falls far outside what is a reasonable definition of unethical, because number one, it conflicts with the SEC's rule. Number two, it conflicts with the common law. And number three, the Secretary has pointed to no authority outside the state that has adopted a similar rule.
So the Secretary, in your view, is confined to the lowest common denominator, right? Whatever the federal government has done and our sister states have done, or what the Supreme Judicial Court has said, that's it. Nothing above that is unethical, or below that, however you want to couch it. It's frozen in that way.
No laboratories of democracy allowed.
Well, Section 415 of the Act makes clear that the stated purpose of the legislature was to make the law of Massachusetts uniform with its sister jurisdictions and the federal government. And there will be circumstances where norms will evolve in the industry. Every other time the Secretary has enacted a rule pursuant to the dishonest and unethical provision, he has based that rule on industry norms, either on rules adopted by FINRA, the Financial Industry Regulatory Authority, and I'll just note that that is not the industry regulating itself, because those rules have to be approved by the SEC pursuant to notice and comment rulemaking. He has based his rules on the model rules.
Your point is the Secretary can't be first. There has to be some other lead somewhere else in the nation in order to follow.
There has to be some hook to what is unethical.
It has to, the only hook there has to be is whether or not, unless there's preemption, or unless this statute collides with the common law and its application as opposed to being able to coexist with the common law, the only question is whether or not the language of the Uniform Act delegates the power to the Secretary to be able to provide these definitions.
That's correct, and we think the answer to that question is no, because
Doesn't it provide for broad powers as necessary to be able to, and appropriate to further the public interest? That seems like a broad delegatory language.
there are three restrictions on that broad delegation. Number one, it needs to be consistent with the provisions of the Act. Number two, which includes the plain meaning of the word unethical. Number two, it needs to be consistent with the purposes as stated in the Act, which includes Section 415, which requires uniformity. And number three, it needs to be necessary and appropriate to carry out the provisions of the Act, not just to do anything that he wants to protect consumers. This court has made clear.
What's our standard of review on his delegation?
Well, of course, the overall standard of review is de novo. Now, this court does defer to agency rulemaking, but not when it's inconsistent with the provisions of the Act, and not when it's an unreasonable interpretation of the Act.
So the Act allows the Secretary to regulate and define the term unethical. He puts out a provision, and we defer to him unless we find he's exceeded his authority to define the word unethical.
Correct.
Can I add something to that?
Yes.
So this isn't the federal SEC where they also talk about industry choice. The whole purpose of this act was to protect consumers. So why isn't what the leading from the front in terms of protecting consumers in what the Secretary has promulgated with definitions, how is that inconsistent? I'm just struggling to figure out how it's inconsistent when there's a broad mandate from the legislature saying go out and protect consumers, not protect choice, consumers. And that's what the Secretary does.
The legislature's mandate is twofold. It's to protect consumers and to strive to maintain uniformity. And when the court is construing the words unethical and dishonest, and those words have to have some meaning beyond the Secretary's say-so, that instruction to make the law uniform should lead to an interpretation of those words, which every other state court has adopted when construing the exact same language in the Act.
But when you're saying uniformity with what?
Uniformity.
Because I'm looking at it differently. Because you keep saying uniformity with what the SEC is doing or what other states have done. But doesn't the Act itself say consistent with what we want to do? Not what consistent with other states, consistent with what the purpose of us promulgating this statute, which is to protect consumers. And I'll read it. The Secretary may, leaving out the words that don't necessarily apply, the Secretary may make rules as are necessary to carry out the provisions of this chapter, including defining any terms insofar as the definitions are not inconsistent with the provisions of this chapter. So they're talking about what their baseline protection is, and that's for consumers. So why isn't this consistent?
Because Section 415 is part of the same chapter. And
Sure.
Section 415 says this chapter shall be so construed as to effectuate its general purpose to make uniform the law of those states which enact it. Now, again, there may be circumstances where, of course, the law is not going to move in lockstep across every state, but in interpreting what the words unethical and dishonest mean, they have to have some meaning beyond the Secretary's say-so, and the meaning that every other court has given to those words, which is consistent with their plain meaning in the dictionary, is that those words reflect industry standards. And industry standards are uniform across the industry. The Secretary has previously had no problem discerning what industry standards are because every other rule he's promulgated
Well,
are
wasn't
based
the whole
on.
point of regulatory best interest and the Dodd-Frank Act was the industry wasn't really doing such a good job of policing itself, and so we needed to up the ante?
No, I don't think that was
No,
the,
what do you think the purpose of Dodd-Frank was?
well, the purpose of Dodd-Frank itself was manifold. The purpose of
But
this,
relevant to this.
Sure, well, relevant to this, Congress instructed the SEC to consider whether a fiduciary duty standard should apply both to investment advisors
But the
and to
question is
broker-dealers.
for what reason? It was because of consumer confusion.
Sure, I take the Secretary's primary premise to be that he thinks the law as it exists or as it existed is confusing to consumers, and therefore the law should be changed to match consumer expectations. That
Right,
is an
so even the
argument.
federal government changed the standard from suitability to best interest. And you're saying the best interest has somehow become a ceiling. And I'm wondering why the secretary can't, within the broad rulemaking authority that he's got, define, to make a bigger delta.
Sure. So let me give 2 answers to that. I think, first of all, it's quite important that Congress expressly authorized the SEC to consider whether to make this change to the law as it relates to the duties that broker-dealers owe. And there's no similar delegation of
Well,
authority.
what Justice George just read, my goodness, that is one broad delegation to the secretary.
But it's not a delegation to change the law. And the law that has existed in this Commonwealth for a century is that broker-dealers do not owe fiduciary duties when they make recommendations.
It may not be expressly saying change the law, but it's certainly not saying have it frozen for all time a century ago. And given that the SEC was charged with changing the law by Congress, why can't we, in the interest of uniformity, or I should say the secretary, in the interest of uniformity, also change the standard, given the broad rulemaking authority that the secretary has been given?
Well, I think if he had enacted a rule that says you should comply with regulation best interest, we wouldn't be here.
Well, he wouldn't need to
But,
do that, right?
well, if he wanted to bring an enforcement action against a broker-dealer.
Sort of a piggyback action, but he wants his own action. He wants to make sure that Robinhood and broker-dealers who dip their toe into giving advice also avoid, mitigate, or moderate any conflict of interest.
Sure. Well, let me address that from the preemption argument, because we haven't quite touched on that yet. With respect to preemption, the SEC regulation itself has preemptive effect. It is just not the case that you need to have an expression of preemption from Congress and a statute. The Supreme Court has said over and over again that regulations themselves have preemptive effect. It said that in Geyer, it said that in Merck, it said that in capital cities. Regulations are federal law, and federal law preempts state law. The SEC made quite clear when it enacted Regulation Best Interest that it was rejecting the Secretary's proposal. It expressly rejected the without regard to language that he adopted in his rule. And it did so because it feared that language would make it difficult to maintain the traditional broker-dealer model, because it could be construed to require complete elimination of conflicts of interest. And it viewed that as a negative policy outcome for there to be fewer broker-dealers offering services pursuant to a broker-dealer model. It had the express purpose of wanting to maintain
Counsel,
investor
may I ask you,
choice.
when that was promulgated, wasn't the SEC aware of other states that had imposed these fiduciary obligations in the?
It was aware of states just like Massachusetts that imposed fiduciary obligations in various circumstances, like when there is discretion and control over an account.
Sure. So I'm posing that in terms of what you just said. So wouldn't this be the exact circumstance where if they were going to expressly preempt, they would say so when they're aware that other jurisdictions do exactly what you're saying they rejected? Wouldn't this be the place to say so?
No, I don't think so. I don't think you can read anything in the SEC rulemaking to say that the SEC thought there were states that are already doing what Secretary Galvin is doing. In fact, he said he was the first of its kind. It simply said there are various approaches to fiduciary duties out there in the various states, just like Pat
They
says.
expressly recognize that. What was it, Section 913, maybe? They expressly recognize.
And then they punt?
Right. And so that's why it would have been inappropriate for the SEC to attempt to express what would or would not be preempted, because there were too many different articulations of the law.
In that provision, they expressly punted on the issue of preemption.
They punted to your honors. They punted to the
Speaking of
courts.
punting, we're in the fourth quarter, so.
Yes.
Will we ask if there are any further questions?
No, Justice Gazio.
All right, I'm gonna blow the whistle. All right.
Thank you.